For estate, business, and tax planning reasons, some producers structure their operation in multiple entities, helping to minimize the self-employment tax. However, the IRS has a self-rental rule that can cause complications. Roger McEowen with the Washburn University School of Law joins us now for today's Rural Money segment. Thanks for joining us, Roger. And let's start with some of the basic passive loss rules.
Well, good to be with you, Christina. And you're right. We do tend to structure multiple entity businesses for farmers and ranchers and have one entity own the land or own the land individually and lease it to the operating side of the business to minimize or eliminate self-employment tax. But it does create an issue with the passive loss rules. And what those say is that if you're going to be passive in a business and have passive income generated from that, and if it loses money, you can only deduct that against other passive income. So I can't use my passive rental income to offset, and if that's a loss, to offset income from a farming activity that I'm involved in. Doesn't work that way. Those rules were put in place a little bit over 30 years ago, and it really makes it tough to deduct passive losses.
How can we avoid these issues?
Well, there are really two ways to avoid. One is to materially participate. But, of course, if you materially participate, you're going to have self-employment tax. But if there's a loss, you're going to be able to deduct the loss. The other one is to create passive income. So if the rule is I can only deduct passive losses against my passive income, well, then I need to invest in another activity that has passive income and not materially participate in it. Well, if I do that, the problem is the IRS also has rules of recharacterization, and they can change what you think might be passive income to active income, so then you don't get to deduct the passive loss. So you're kind of stuck between a rock and a hard place.
Okay, so as I understand it, passive income is anything the earner does not materially participate in during the year. Can you give us some examples of this? Because this is pretty complicated stuff you're bringing to the table, Roger.
Yeah, let me give you, I think, a very common example that we see. And we see a lot of passive-type investments by doctors and lawyers and other professionals. So let's say we've got a medical doctor that owns interests in multiple limited partnerships, and they have suspended losses. He hasn't been able to deduct the losses, so they're just hanging there waiting for him to have a year when he can deduct them. He's got income to use. In an attempt to use those losses, he goes out and buys farmland. Say he buys it for $400,000. He allocates $100,000 of that to depreciable items such as fences and tile lines and grain bins. He then cash leases that land. He doesn't want to farm it, so he cash leases it to his cousin under a cash rent lease. He's going to try to generate, the doctor is, passive income from that cash rent lease so that he can use those suspended passive losses. But in this instance, because he doesn't have enough depreciable property to allocate basis to, it's not going to work. He's not going to be able to use that passive rental income to offset his passive losses. So that's a very typical scenario we see in ag, and if you're not careful, it's not going to work.
Yeah, especially when it comes time to pay the tax man, you could be caught off guard. Thank you so much. We always appreciate your examples. Roger McEowen with the Washburn University School of Law. Thank you for joining us. And you can find more from Roger. Just do a Google search for Roger McEowen. He has a great blog going.